Hello, my name is Professor Luke Nottage from the University of Sydney, co-director of the Australian Network for Japanese Law, ANGEL. I'm very pleased to welcome a special guest for an interview today about consumer law and policy in Japan. Professor Souichirou Kozuka is Professor of Law at Gakushuin University in Tokyo, specializing in actually many fields of business law, not just consumer law, but also commercial and corporate law. He's a convener of ANGEL in Japan and an active contributor also to the Journal of Japanese Law that ANGEL supports. And he's been my co-author over many years in various areas, including Japanese corporate law, consumer credit, and contract law reform in Japan. So thank you very much for taking time to share valuable insights today for my students and hopefully the wider public about some interesting developments in consumer law and policy in Japan.
Hello, and thank you very much for inviting me, and thank you for your kind introduction.
Thank you. So this podcast interview is actually prompted because you have been appointed to the Consumer Product Safety Investigation Committee within the Consumer Affairs Agency of Japan, which was set up around a decade ago as an independent agency to promote consumer affairs and enforcement and law reform in this field. But as well as the Consumer Affairs Agency, there was also something set up called the Consumer Commission. So before you talk about the Consumer Product Safety Investigation Commission that you're on, perhaps you can explain where that sits within the Consumer Administration and also the role of the Independent Consumer Commission. So what are its memberships and functions compared to the commission, the commission you're on and the Consumer Affairs Agency, please.
Yes, and that is a very crucial point and in examining the consumer law and policy in Japan. And it's very complicated, so I have prepared a figure. So if I may, I'd like to share that figure with the audience. Okay. Hope it works. Okay. Can you see my figure now? Okay. Yes, and this is how things stand now in Japan. So administration, basically lawmaking and also implementation and enforcement of laws are in the hands of mostly a consumer affairs agency, which was established in 2009 with the aim of enhancing consumer protection of consumer interests. And together or in collaboration with other ministries, and so when the Consumer Affairs Agency was established, and actually statutes relevant to consumer interests were scattered across various government agencies. So most of them are now under the jurisdiction of a Consumer Affairs Agency, but some have remained as kind of a co-jurisdiction of Consumer Affairs Agency and other ministries, such as a Ministry of Economy, Trade and Industry, MEDI. And one example is the law on specific commercial transactions, which regulates door-to-door service and tele shopping and other very kind of suspect commercial transactions. And so that law is amended and enforced by both agencies at the same time. And then there is this Consumer Commission. It is an independent commission. So unlike ordinary government councils or shingikai, which most of the Japanese government agencies have, and it is independent from any agency and rather in position to monitor the administration by Consumer Affairs Agency as well as other ministries. It is quite strange. It is quite unique and also strange, I would say. And there is a political background, in fact. When Consumer Affairs Agency was established, the law for that purpose was enacted in 2008. And those who have studied Japanese law and politics may know that in 2009, the political handover from the center-right government led by LDP to center-left government led by DPJ, it took place. And so in 2008, already this opposition group led by DPJ had a big seats in the Diet. And they, of course, claimed for stronger protection or advocacy or advocation of a consumer interest. So they said that no ordinary government council is not sufficient. You need to check and monitor what government agencies are doing. I think it is kind of distrust in the bureaucracy of Japan. And I'm not sure whether that was a good policy or not, because in other fields, and that kind of hostile attitude towards government agency didn't work. And after all, a DPJ-led government collapsed only in 3 years. And now a LDP-led government, again in power, has been more collaborative with the government agencies. But anyway, in consumer policy sector, this structure has remained. Mm-hmm. So Consumer Commission now has 10 members. Some of them are law professors, but others are representatives of consumer groups, and also a representative from the industry. And at present, one of the members is an economist, a professor of economics, and another professor is a professor of engineering in products.
Right. So, and their role is primarily to supervise what the Consumer Affairs Agency is doing and implementing in terms of its laws, and maybe to propose that they investigate new reforms or new issues for consumer law. Is that right?
Yes, and I would say that they are more concerned about what Consumer Affairs Agency is not doing. So, and what is neglected and what needs to be addressed. And so Consumer Commission makes proposals from time to time.
Right, thank you. So if we compare that with, say, Australia, we have a combined competition and consumer commission as the regulator enforcing the law, but they're not supposed to be driving policy and law making. In theory, that is the role of the ministers of consumer affairs, so the federal assistant treasurer and state and territory consumer affairs ministers. But of course, their staff is pretty limited, and so they often have seconded officials from the federal regulator, the ACCC, and then the state consumer protection regulators as well, to help them develop law reform proposals, but then those are put forward by the ministers and passed through Parliament or under delegated legislation. So, and the idea there is also that you're trying to split the law enforcement aspects from the policy and law reform processes, even though in practice there is some overlap. But Japan has this curious hybrid where the Consumer Affairs Agency is both enforcing the law and developing policy, but then you've got this separate independently appointed Consumer Commission with experts that's supervising everything that Consumer Affairs does, and suggesting especially new areas that they need to be looking at, or new issues. So very fascinating, typically fascinating Japanese hybrid model, maybe the result of political compromise, maybe working well or not, probably too early to say, even after 10 years. But perhaps you'd like to also please tell, in light of time, just explain the next question, which is the commission that you're involved in, you've been appointed to, on consumer product safety issues specifically. So would you like to explain where that sits in this regulatory scheme for Japan and what it does?
Yes, and so a Consumer Safety Investigation Commission is a commission under the Consumer Affairs Agency. So it is in the kind of the mainstream, I would say, and a line of administration. And its role is to go into the causes, look into the causes of incidents, in particular serious incidents involving consumers. So I have another figure to share with the audience. So this is it. Yep. So a Consumer Safety Investigation Commission and so the commission, first of all, the inspiration comes from the Japan Transport Safety Board, which makes investigation into the cause of traffic accidents, serious traffic accidents, like collision of trains. And so the idea is we need to prevent a reoccurrence of serious incidents. And in order to do that, you first need to understand exactly what was the reason or what was the background of the incident. Not only the structure or materials of the product, the dangerous product itself, but also the background of the business model, or background of the industry, or background of the warnings and marks indicated in advance of use by consumers. And one point different from the Transport Safety Board is that we cannot examine all the consumer incidents, because consumer incidents are so abundant, unfortunately, and so we need to be selective. And in order to do so, the commission gets information from two sources. So one of the sources is the Consumer Affairs Agency itself. And under the law, the Consumer Affairs Agency has the power to collect all reports from government agencies, local governments, and also a National Center for Consumer Life about consumer incidents. So, from among the collected reports, the commission looks into which of the incidents need to be looked after, and a investigation be made, so that similar incidents are prevented from happening again. Right. Another source of information is individuals. So an individual is allegedly damaged in the incident. So I got this trouble and I was damaged. So I want the commission to look into the investigation. Of course, it depends on the case, but these reports may include something very something serious, and something that needs to be addressed by the commission. So, and that is how the commission starts investigation.
Thank you.
Then,
can I ask, so a question on, so you're assembling information from different sources. If I'm a consumer harmed by what I think is an unsafe product in Japan, or I'm maybe a family member on their behalf, or a consumer organization, and I will want to complain about this so it doesn't happen again, and maybe get compensation if necessary for the harm, We could go to the consumer lifestyle centers you mentioned that are sort of these mostly local government funded consumer offices, mostly with part-time staff, but who help sort of mediate the dispute if necessary, and some national bodies under this Consumer Affairs Agency. And then that information then gets picked up and fed through to your commission. But if you don't want to go that route and you just want to complain directly to the government, and so that doesn't happen to other people and so on, you can make a direct report. So when you make a direct report, does the commission have its own dedicated hotline or website? And then if it's got a website, is that website, are the complaints like public? Because in the US, for example, in 2008, they set up a new US government website after some problem with imported Chinese toys in particular. And so anyone sort of can complain about a problem, consumers, doctors, and so on, and it's actually public. And there's even an opportunity for the supplier to respond and say, well, it's not our product, or it was misused, or we don't think it's unsafe, or we're sorry. Although in America, it's risky to say you're sorry because you might have a class action lawsuit, but, and so it's actually public. But in Australia, we don't have a sort of public register of complaints like that, even for safety issues. So what about Japan?
Well, and yes, the commission or the Consumer Affairs Agency has accepts a direct complaints, so by phone and also by through website, and this is open to the public, and then the commission takes up all of these complaints and examines whether the investigation needs to be started or not. When the investigation is not started, then through Consumer Affairs Agency, a response is given to the complaining consumer that the commission has decided not to go into investigation for this and this reason. For example, the complaint is too vague, so investigation is not possible. That is it's just one example.
Right.
And so in that sense, it is public, available to the public, and is quite open.
But the fact of the complaint, the complaint launched is not displayed on a website. It's kept private between the complaining consumer and the agency or the commission, right? So,
well, and I'm not sure about the details of the complaint, but at least the kind of the statistics or so are reported in the annual report of the commission.
Yeah. Statistics, depersonalized statistics are kept, right? And then my other question is, the information comes in from these different routes. The commission investigates. It decides, well, and if we're getting lots of sufficient examples of serious harm for these consumer products, we haven't got, for example, a mandatory safety standard for that type of good. It's time to develop that standard. Can the commission or the Consumer Affairs Agency that it's part of then proceed to develop the mandatory safety standard? Because in Australia, for example, it's the Minister for Consumer Affairs who sets the standard, but he's advised actually by the regulator, in particular the ACCC. They do a public consultation and recommend either that there's a new mandatory safety standard for performance or information like warning labels on certain unsafe products. And actually there's a reform discussion consultation now about amending the Australian law to specifically allow the minister to adopt a recognised foreign standard from a foreign standard setting agency, usually a government one, for example, but maybe others as well. So does the Consumer Affairs Agency and the Commission have that power in Japan?
Well, short answer is no. And first of all, the Investigation Commission, its mission is to investigate the cause of the accident, and so it is not in charge. It does not have the power to make rules or standards, but it does have the power to make recommendation urging relevant regulators and relevant government agencies to take action, including introducing or improving the regulation. So in that sense, the Commission doesn't make standards of its own, but it urges a relevant government agency to introduce a safety standard.
Right.
And,
so,
yeah.
So can I ask then who, if the Consumer Affairs Agency wanted to set a standard itself, does it have the power under the Consumer Product Safety Act, or must it always defer to another ministry to set the standards? Because this is a big issue in Southeast Asia as well. So unlike Australia, many countries, even with quite powerful, well-established consumer agents, regulators, they don't have these sort of pre-market powers to set mandatory safety standards for certain types of goods. They can only usually have these post-market interventions to ban unsafe goods and so on. And of course, because they have that power, they can informally influence the other ministries to set a safety standard, because otherwise they'll end up banning the goods or forcing a recall. But they don't have a statutory power like in Australia or New Zealand, except in some countries like,
Yeah, in that sense, Japan is not on the Australian side, but on the Asian side. So Consumer Affairs Agency does not have the power of making standards. And just like an investigation commission, a Consumer Affairs Agency itself has the power to urge other government agencies to take actions. And also with regard to ordering recalls, or including ordering the repairs to the defective products, a Consumer Affairs Agency has the power to do that when there is no other government agency to act. That was one of the big programs that was behind the establishment of Consumer Affairs Agency. So regulatory gap program.
But if you, for example, sorry to interrupt, if you find a product, say, with a new type of child's products, which often, are the sorts of products that are regulated through mandatory safety standards around the world, because it's a product that's regulated, say, in this case, by the Ministry of External Trade Industry, all the Consumer Affairs Agency can do is encourage the other ministry to develop a new standard for this. Right? That's the situation? Because the tension then is, well, what if the other agency doesn't do anything?
Yes, of course, there is a possibility of that, but a Consumer Affairs Agency is a kind of advise, or I use the term urging other government agencies. So the implication is very strong, and the Investigation Commission even had the power to summon the government officials in other government agency and ask them what actions were taken and what they think about the effectiveness of the action they took. So there is a strong pressure on other government agencies. And may I share another slide? This explains the statutory framework. So for technical standards, the primary statute is Consumer Product Safety Act. It is, in fact, very old, and it is implemented by the MEDI. And for specific products, there are other laws. For example, food sanitation act for food. And a Consumer Safety Act was enacted to fill the regulatory gap, but it appears that filling the gap works only with regard to recall and demand for repair or other kind of ex-post remedies. And for ex ante and a standard setting, and a Consumer Safety Act only authorizes Consumer Affairs Agency to advise other government agencies to enact a new law or to add a new statute, a new provision to the existing statute.
So is this even if there is a identified gap? So for example, I think a famous example that actually helped to lead to this new Consumer Safety Act of 2009 and the new Consumer Affairs Agency independently was the konjaku jelly snacks.
Yes,
right?
exactly,
And it's like, well,
exactly.
it's not a problem of contamination with these snacks. It's just that the very nature of the goods with this sort of viscous, root vegetable and as a binding agent for these snacks instead of gelatine, which is softer, means that particularly elderly people and young children were like choking on them and dying. And because it's not a contamination issue, it's not covered by that law. Because it's not an industrial product, it's not covered by METI. It sort of falls in a regulatory gap. So the response was, well, we need a new agency and new laws to pick up these unsafe products and obviously ban them if they're already on the marketplace. And that is, but you're saying that they just make recommendations to the, well, they can ban them in those situations under the new act, but they can't, for example, set a ex ante new mandatory standard for these products that are not covered by other laws and regulators, right? So they, like in Australia, we didn't ban konjaku jelly snacks completely. The consumer regulator, not the food regulator, the consumer regulator, because it can cover all products, they set a new mandatory safety standard, which is konjaku jelly snacks can only be supplied if they're a large size, which no one, even an elderly person, can swallow in a whole, and so it's much lower risk because you have to cut them or chew bits off or whatever, so it's much safer. And under the Australian consumer law, the consumer regulator has that power. But you're saying in Japan, even under this new legislative and regulatory framework, they don't have the power to set the free market standard, and they would have to ask someone else to develop the standard. Is that right?
Yes, it's very interesting to see this kind of difference in approach. So, and yes, the short answer is yes. And the idea in Japan is that, okay, so now the Consumer Affairs Agency has the power to recall and ban the marketing of the product. So unless other government agencies introduces new standards, the product doesn't go to the market. So products can be stopped, and then Consumer Affairs agencies say, okay, for example, and Ministry of Food, and you introduce a new standard. Otherwise, this product will never go into the market again.
Yes, but the premise is that the new product is falling in a gap between the different ministries and the legislative regimes, like konjaku jelly. It's not within the jurisdiction of the, Ministry of Health and Welfare, because it's not a food contamination issue. It's a problem with the design of the product and or warnings, right? And it's not an industrial product. So METI hasn't got any law to regulate this and set a safety standard. So at the moment, the Consumer Affairs Agency could only sort of go to Parliament and say, we need a new law just on konjaku jelly minimum standards. Is that right?
Well, of course, it can say so if it wishes to do that. But a more plausible scenario is go to the Ministry of Food and say, okay, you add konjaku jelly to your jurisdiction.
Right.
So for pre-market measures, so changing the jurisdiction of government agencies is possible. So advice could include that, okay, if this is not regulated now, this and this government agency must add it to its responsibility and introduce a kind of a broaden the regulatory power to cover that new product.
Right.
And until that takes place, the products are stopped from going into the market.
Yes, it sounds like yeah, it sounds like a sort of political compromise for a new, less resourced consumer affairs agency, and a similar problem to what we find in other, for example, many Southeast Asian countries with less established consumer protection laws and enforcement. So that's very interesting from a comparative point of view. Thank you. The other comparative observation I have, going back to your Consumer Safety Investigation Commission and how it can sort of recommend improvements in the future. A comparative analog might be in Australia, coronial inquests, which are sort of quasi-judicial, but the coroners have much more sort of investigative powers, and they have lawyers assigned to assist them, and they make more investigations, and the primary function is to identify what happened, like why did this person die from a Takata airbag in a Honda car recently, a few years ago in New South Wales, and make recommendations for what the government should do to make sure this doesn't happen again, with some possibility that facts discovered might lead to the criminal prosecutions. But primarily, like your Consumer Safety Investigation Commission, just trying to find out what happened and recommending what might happen again. So is there also a role in Japan for coroners, coronial investigations, that and how, in which case do you coordinate with them as a, I mean, there could be parallel inquiries even, perhaps.
You mean parallel inquiry by
your commission,
the investigation commission and for example, and
a coronial inquest, or do you not have any system for an independent inquiry of deaths generally? Like this includes things like even like if the cause is uncertain, then it could be a murder, or it could be like a strange disease or illness, and the coroner can be asked to investigate, and it might take a year or even longer. Like with the Takata airbag inquiry in New South Wales recently, it took many years, partly because of the pandemic, but also it was a complicated case. I gave evidence in that inquiry about the recall notices issued by Honda and so on. But is there something like that also that might happen in Japan?
We don't have the exact counterpart of the concept of coroner. And when there is a possibility of a criminal incident, and then the prosecutor steps in and checks whether the cause of the death is criminal or not. When it is not, the prosecutor's office simply says, "Oh, it was not criminal," and it closes the case. More on the medical side, when a medical doctor is involved, when a person dies, then that medical doctor gives an assessment of its own, and then that report will be shared by the police and prosecutor's office. And so that a procedure by the prosecutor's office starts. And in Japan, the system is when there is something criminal, then the criminal procedure starts. And when there is a suspect for criminal incident, then the pre-criminal procedure works.
Yeah, so it's a bit different, though. It's different to a coronial inquest because that may not lead to any criminal investigation. It might just be the first step of working out what likely happened, and or how we can avoid it in the future. So it's just working out the facts, and then so it doesn't happen again. So it does seem to have an overlap with what your commission is doing for consumer product safety investigations. So maybe that's a subject for our future research.
But anyway, when there is a incident involving a people's death or injury, then it is in practice, it is quite likely that the police is called.
Yes.
And then the police makes investigations.
Yes.
And even if it is not an intentional and a crime, and
Yes.
still there is a possibility of a criminal sanction for faulty
Yes.
injury of people.
Yeah.
And so police anyway comes in.
I
And
suppose
so
it's different though, because the police are not
yeah,
they're not conducting a sort of quasi-judicial independent inquiry, and the police can't say, well, we're going to prosecute you, and now we're going to recommend to the government that they enact new laws to stop it again. That's not their role, right? So
no.
it's the role of your commission, right? So
Right.
yeah, very interesting. Thank you.
Yeah. So anyway, the procedures could be a proceed in parallel. So Consumer
Yes.
Investigation Commission and the criminal investigation
Yes.
could proceed in parallel. And this Consumer Investigation Commission is the investigation, and its investigation does not connote any pursuit of civil or criminal liability. This is the important point. Otherwise, people will try to conceal the truth. But,
yeah. So in that sense, too, coronial inquests might have some parallels. So we've only got limited time left, but can I ask you to talk finally about the more common types of everyday consumer disputes and problems, which is around consumer contracts, please? Even though your primary role now is on the consumer product safety side.
Yes, for consumer contracts, and we have the Consumer Contracts Act, which was enacted in 2000. And when it was enacted, it was a rather simple law. And it was something like kind of a bit expanding the civil code. So instead of duress in the civil code, it says, okay, so when a consumer is embarrassed by the or harassed by the seller, then the consumer can cancel that transaction. Now, when you open a law book, you are quite surprised by the so detailed a provision on the types of businesses that entitles consumers to cancel the transaction. This is in contrast with the latter part of the Consumer Contracts Act, which deals with unfair trade terms. Unfair trade terms has been there since its enactment, and it has not been amended much until now. So it has rather been the role of the court to use the general clause, a kind of general clause in the Consumer Contracts Act, saying that when a clause in the consumer contract is extremely unfair in light of the principle of good faith, then it is void, null and void.
Yeah. So what do you think explains this? So the Consumer Contracts Act is again somewhat influenced by EU law developments, two directives. On the one hand, the directive now of unfair commercial practices, which is trying to stop sort of misleading advertising and pressure in the pre-contractual phase. And then if that's proven, then under the Japanese law, the consumer gets a right to terminate the contract, get out of the contract, right? And then the latter, and that's the area where over time there's been amendments to the 2000 Act in Japan, which has said, well, the types of transactions or situations where the consumers can apply to get the contract terminated are as follows, and they're quite detailed, and more of them are listed and so on, to maybe help the courts to know, when to allow these rights. Like, things like, I was surprised, the ones about, giving sort of misrepresentations about one's romantic, the salesperson's romantic involvement with the customer and leading to the customer taking on some onerous contract terms, or preying on their religious sensibilities about the afterlife, and to say, well, that's a problem area. But on the other hand, as you said, the other part of the Act is based on the EC unfair contract terms type directives, so very sort of broad provisions saying that if they're very one-sided and contrary to good faith, then those terms are void. So that's the substance of the contract once concluded. So the rest of the contract could survive, but those particular terms are not enforceable against the consumer because they're unfair. And that's remained quite broad. There's not even a grey list of terms that might be unfair, which is found in the EC directive. So why is Japan going law reform quite specifically in the first pre-contractual phase, but not in the substantive contract terms void phase?
Yes, that is a very curious thing, in fact, and I think there are two reasons, and in particular with regard to the fact that for the first part is becoming a more and more detailed, and there's a background on the consumer side and also on the business side, and on the consumer side. Consumer advocates like consumer groups or consumer lawyers, they tend to have the view that consumer law is pretty much policy oriented and is separated from the general civil code. Civil code professors who are often interested in consumer law do not agree with this idea, but consumer specialists say that, oh, consumer law should be policy oriented and it should be quite responsive to what is happening now, and amendments need to be made quickly in response to the new type of a malpractice. And what happens is that when a new type of a bad business is reported, then that is tabled before the Consumer Affairs Agency or the Consumer Commission, and then the advice is made. Okay, so the Consumer Contract Act needs to be amended to respond to these new types of transactions. On the business side, and business industry representatives think about how to comply with the law or when the amendment is made. So they say, okay, if the law is a general and not specific, then it will be extremely troublesome and costly within a company, especially a big company, to do compliance and with the amended law. So they say clear-cut rules, please, more specificity, no vagueness. That is the demand from the business. So curiously enough, these two demands match and end up in a very detailed description of the malpractice regulated by the Act, which is, of course, very awkward, and it ends up in the bad guys easily finding a loophole, and then that gives rise to the agenda of the next round of law reform. So that is, but I don't think that is effective.
Yeah, that's very interesting. When I launched, had asked the former Chief Justice of New South Wales, Tom Bathurst, kindly to launch two of my books, actually, one on ASEAN consumer law that I co-authored, and another one on Japanese contract law. He actually was quite impressed by this detail of the amendments to the Japanese Consumer Contracts Act, because in Australia we have some particular types of unfair practices, like, you know, pyramid schemes and so on, that are specifically regulated and so on, just like Japan. But then we have these emerging problems which we try to deal with broad prohibitions against unconscionable conduct. And from a judge's perspective, even when there's a list of factors listed in the statute, they're quite hard to weigh up and structure and apply. And so this senior Australian judge said, well, in his book launch comments, which are on my website at the University of Sydney, said, well, this could be quite helpful, because then we get a signal from the legislature. They are particularly concerned about this type of bad practice. And we, as part of the judiciary, need to also be aware of this and help clamp down on it. So So it's also the courts, I guess, that might in some ways prefer more detailed rules sometimes, but you still need the broader prohibitions as a fallback in case it doesn't fit within one of these categories. And so, so in Japan, curiously, like for unconscionable conduct, we find that instead, as an aspect of competition law and unfair trade practices enforced by the Japan Fair Trade Commission for abuse of a dominant position and so on, but more between commercial entities rather than commercial suppliers and consumers. But my question is, after the comparative observation, my last question for our interview really is, those same reasons could be applied to the post-contract phase, the unfair contract terms, because we always find clever lawyers coming up with new types of unfair contract terms, particularly in the digital age. Someone just copies and pastes, or they find out something they see online, someone else's term, they think, oh, that's nice. It gives us all the advantages, and the consumers, will have to do all this stuff to claim their remedy or not. And so they copy it over into their online contract terms, which all consumers just click, including myself, because otherwise it would take you hours and hours to read this, and anyway you can't negotiate these terms, right? And so as I said, in the EC directive, there's a sort of list of a gray list of possibly depending on the situation, unfair terms like unilateral variation clauses that give all the power to the consumer if they give some short notice to change the terms, and that allows the regulators and the courts in a way to say, okay, well, that's a suspicious type of clause. And you could imagine in Japan, for the same reasons, consumers saying, well, let's have a list like that in the Consumer Contracts Act. And then businesses, the reputable ones at least, saying, yeah, that's all right, because we don't use those terms, or we don't want to have to compete with other less reputable firms by having all these unfair terms. It's bad for our reputation and so on. So does it not happen in Japan because maybe the contracts aren't drafted in this sort of nasty, unfair way? or why don't those two reasons apply to the unfair contract terms part of your act?
Well, I wish to say yes, but I don't think Japanese businesses are especially particularly kind of a favorable to consumers in drafting, and so that may not be the reason. And I think the reason is with regard to unfair terms. It is less likely that complaints made to the Consumer Affairs Agency or National Center for Consumer Life. So for inducement of transactions, people say, oh, we were frauded, we want to take our money back. But for unfair terms, and complaints come up, but they do not go to these agencies or centers, so they are not reported as a cases to be addressed by the Consumer Contracts Act. And on the other hand, from lawyers, consumer lawyers side, and of course they have been arguing for the gray list, and which is not acceptable because gray is a vague and so not acceptable to the business side. And when expanding the blacklist, a prohibited list, consumer lawyers might think that, well, if we have that detailed list, then the courts could say, okay, something that does not fall under these lists are wide and so not prohibited. And that's not good. So here the interest is rather to keep the list minimum and let the court decide.
Right. I understand.
After a dispute arises. And you may know that Japanese judges prefer to have free hands under the general clause. So here the balance comes in the opposite.
Yeah. Interesting, very interesting. Well, thank you very much for these cutting edge explanations of what's happening in Japan, allowing us to make some comparisons with what's going on, for example, in Australia and around the region, Southeast Asia and other parts of Asia. So thank you very much for your time today. I hope we get another opportunity to perhaps have a separate interview discussion about how Japan is trying to cope with digital transformations and the explosive growth in e-commerce, particularly since the pandemic and so on, and all sorts of new problems. I think that's another common issue that countries are grappling with. But thank you again for taking time to share all your knowledge and interesting comparative observations with us. Thank you.
Well, it has been my pleasure, and I quite agree with you that comparison is always a good approach to the law issue, including consumer law. So yes, I look forward to further collaboration among us under the framework of Angel, probably.
Thank you very much.
Thank you.